So the Dobbs dads might bring it home for Kamala Harris. One of the biggest things that people are pissed off about when it comes to Trump is this overturning of Roe v. Wade. And Dobbs versus Jackson's medical something, the Dobbs decision of 2022 is going to be something that may get Kamala Harris elected, which is a little bit ironic. Don't you think? So Amber Nicole Thurman, they said maybe one of the first people to have died because of the Dobbs decision. Amber Nicole Thurman was a 28-year-old medical assistant who died of septic shock and retained products of conception following delays in her medical care after her abortion. Georgia's Maternal Mortality Committee determined that Thurman's death was preventable and noted that the delay in performing the dilation and curettage procedure, D&C, significantly contributed to her death. August 2022, Amber Nicole Thurman traveled to North Carolina where abortion remained legal and received abortion pills mifepristone and misoprostol. After taking the medication, she experienced a rare complication, incomplete expulsion of fetal tissue, which resulted in a severe infection. Any doctor who violated the new Georgia law could be prosecuted and face up to a decade in prison. Thurman waited in pain in a hospital bed, worried about what would happen to her 6-year-old son as doctors monitored her infection spreading, her blood pressure sinking, and her organs beginning to fail. It took 20 hours for doctors to finally operate. By then, it was too late. So RIP to Amber Nicole Thurman. She was the first fatality of the Dobbs decision. Now here's an article that's titled "The Supreme Court May Use Dobbs to Take Down Trans Rights and Beyond" by Susan Rinkunis, October 11th, 2024. The February 2024 Alabama Supreme Court ruling declared that embryos should be considered people under wrongful death laws, in which halted in vitro fertilization treatments, cited Dobbs multiple times. Fucking Alabama, of course. Alabama always got to push the fucking backwardsness as much as they can. And we're seeing another instance of Dobbs' repercussions in a pending case about sex discrimination in medical care. If the High Court accepts these arguments, it could have wide-ranging effects. One of the biggest Supreme Court cases this term, U.S. v. Scrimeti, is about whether bans on gender-affirming care for minors amount to unconstitutional sex discrimination. The plaintiffs, 3 Tennessee transgender youth and their families, argue that the state law clearly discriminates based on sex because it bans medical providers from prescribing puberty blockers and hormone treatments to transgender youth, but allows those same therapies for cisgender kids. To put a finer point on it, under the law, Senate Bill 1, a minor assigned female at birth can take estrogen while a minor assigned male cannot. The Department of Justice argues that the Tennessee law violates equal protection rights under the 14th Amendment. We should not be transing our kids. We should not be transing the kids. Don't need surgeries. You don't need to be taking pills. The Department of Justice argues that the Tennessee law violates equal protection rights under the 14th Amendment. Now, Dobbs can take away like all of our freedoms, like a whole list of freedoms. Griswold v. Connecticut and Mapp v. Ohio. All of them, right? Skinner v. Oklahoma, the right to not be sterilized without your consent, the right to decide one child's education, 1925, Pierce v. Society of Sisters, 1923, Meyer v. Nebraska. Maybe even Loving, Virginia, Obergefell, Turner v. Safly, the right to get married, the right to securities of one home, 1886, Boyd v. U.S., and some other freedoms. Miranda, Cruzen v. Director, 1990. So, in a brief filed on Tuesday afternoon, Tennessee's Republican Attorney General Jonathan Scrimeti chillingly cited Dobbs more than 10 times to argue that its law is a mere regulation of medical care and doesn't discriminate based on sex. The Dobbs opinion made the same claim about the Mississippi abortion law in the case. More specifically, Tennessee claims that SB 1 isn't discriminatory because it only restricts those treatments if the end goal is to transition to a different sex. Scrimetti writes, the provision of testosterone to boys to treat a minor's congenital defect, precocious puberty, disease, or physical injury does not serve the same medical purpose as the provision of testosterone to a girl who wants to transition. The same drug is at issue, but it's used at different dosages and for different medical purposes. Dicta, meaning that it doesn't have the force of law because the issue wasn't before the court. The court had no business making a statement about it in that case, and courts shouldn't be relying on it now. The Fifth Circuit ruled in favor of a conservative father who said a federal program offering contraception without parental consent violated his parental rights. You actually had the governor of Kentucky, Andy Beshear, who just ruled none of the, I think it's the right ruling. You do not want to do surgeries. You don't want to give them a bunch of drugs. Wait for them to be adults, and then when they're adults, they can make their decisions, as necessary. Let's see, the Conservative Blueprint Project 2025 wants a future Trump administration to target insurance coverage of emergency contraception. Now that's Griswold v. Connecticut. And we could also see states passing laws restricting minors' access to those pills and to UDIs or IUDs. The right to use birth control in particular is usually discussed in the context of what's known as substantive due process reasoning, not the equal protection rights at issue in the Tennessee case. Now, Clarence Thomas notably wrote in a Dobbs concurrent opinion that he hoped that the court would revisit other landmark precedents that relied on substantive due process, like Griswold v. Connecticut on birth control, Lawrence v. Texas on same-sex intimacy, and Obergefell v. Hodges on marriage equality. So Clarence Thomas is saying, yeah, let's relitigate Lawrence v. Texas, Obergefell v. Hodges, and Griswold v. Connecticut. Clarence Thomas didn't mention Loving v. Virginia. But a steady chipping away at the right to birth control, starting but not ending with young people, could lead to a future where the Supreme Court overturns the Griswold v. Connecticut decision. Griswold v. Connecticut is a great decision. It says that the Constitution doesn't just protect the rights in the Constitution, but also the peripheral rights. You have a right to speak, and you have a right to, be able to speak. So the peripheral rights, let's say the right to petition. You have a right to petition the government for a redress of grievances, but how do you get that petition filled out? Well, you have a right to ask people to sign your petition. So the peripheral rights are very much essential to the main right. So I like Griswold v. Connecticut. It was about condoms, and they said something about we have sacred marital bedrooms. And so you don't want people going into people's bedrooms and saying, all right, where's these condoms at? Did you use, okay, I know you're husband and wife, but did you use the damn condom? That's illegal. That's illegal. Don't you dare. Do we want cops to be doing this? Of course we don't. The Senate had turned that down. They tried to codify that you have a right to condoms in the Senate, and they turned that down. I like the Griswold v. Connecticut decision. In the poll released Wednesday, Harris leads former President Donald Trump 59% to 39% among college-educated white men, a group referred to by some as Dobbs dads. The term is defined as fathers of girls or young women who may have traditionally voted Republican, but who Democrats think will switch their ballots in November out of concern about their daughters' reproductive rights after the Supreme Court's decision on Dobbs v. Jackson Women's Health Organization, which overturned Roe v. Wade. On the issue of abortion, voters in two swing states, Arizona and Nevada, will have the ability to directly decide the future of access this fall through general election initiatives. Some tragedies are impossible to prevent or even to predict. The death of Amber Nicole Thurman was not. She was perhaps the first woman killed by overturning Roe v. Wade. In June 2022, the Supreme Court ruling in Dobbs v. Jackson Women's Health Organization removed the constitutional right to an abortion guaranteed by Roe. As a result, individual states reverted to their own laws. In Georgia, where Thurman Amber Nicole Thurman lived, abortions became illegal from the time when a detectable human heartbeat was present, which is around 6 weeks into pregnancy. The law came into effect in late July of that year, at the same time that Amber Nicole Thurman, a 28-year-old medical assistant, discovered that she was 6 weeks pregnant with twins. So she just discovered that she was 6 weeks pregnant with twins. In the year after the U.S. Supreme Court dismantled the constitutional right to abortion in June 2022, more than 200 pregnant women faced criminal charges for conduct associated with their pregnancy, loss, or birth, according to a new report. The report was produced by Pregnancy Justice, a nonprofit that advocates for the rights of pregnant people, including the right to abortion. Researchers in multiple states documented 210 cases of women being charged for pregnancy-related conduct in 12 states from June 24, 2022 to June 23, 2023. The first year after the U.S. Supreme Court eliminated the constitutional right to an abortion, throwing the issue to the states. 210 women are going to get wrongful death suits or abuse of a corpse suits. The majority of charges allege substance use during pregnancy in 2/3 of the cases. It was the only allegation made against the defendant. 6 states, Alabama, of course, Mississippi, oh boy, Ohio, Oklahoma, South Carolina, and Texas. So the stupid, dumb, backwards, racist Confederate states accounted for the majority of cases documented by researchers. In July, an Oklahoma court exonerated a woman who'd been charged with felony child neglect in 2020 after her son tested positive for marijuana at birth. Prosecutors pursued the case even though her baby was born healthy and she had a doctor-approved state license to legally use medicinal marijuana to treat severe morning sickness during the pregnancy. Brian Hermanson, an Oklahoma Republican district attorney who's prosecuted dozens of women in his district in similar circumstances, used fetal personhood language in his legal argument. Marijuana is an illegal drug under Oklahoma law unless the person consuming the marijuana holds a medical marijuana license. Unborn babies cannot hold such a license, Hermanson wrote. The defendant admitted to smoking marijuana throughout her pregnancy, knowing that her unborn baby was being exposed to the possible harmful effects of the marijuana smoke. The pregnancy justice, the baby is born healthy and she had a doctor's prescription. So, I mean, shouldn't that be deferred to the doctor? Shouldn't it be the doctor? If anybody who gets charged would be the doctor, right? So you're supposed to be smarter than the doctor. No, doctor, I'm smarter than you and I know what's best. The Pregnancy Justice Report also documented 5 cases in which allegations specifically mentioned abortion. One was brought under a state abortion statute that has since been repealed. The other 4 cases were charged as homicide, child neglect, or abuse of a corpse. Homicide? Homicide. In the 2 cases in which homicide was charged, the defendants allegedly visited an abortion clinic or took pills and the abortion was successful, Rivera said. I feel like the first 3 months you got, an opportunity to get it taken care of, or maybe this first 6 months. But you do have to have a dividing line. If you allow abortion all the way up to 9 months, well, there's partial birth abortions. It's almost a damn baby. It's almost a full child. It's almost a full-grown child. And that means they'll have to kill the full-grown fetus child in order to complete the abortion. Oh, it was birth, and so therefore, once it's been, given birth, then it's a child. But if it's not, there's no birth, I don't know. I just don't like partial birth abortion. So I am pro-choice, so I just feel like there's a dividing line between both of these. Now, even though Trump had pointed out to Kamala, where is the line? And Kamala didn't answer the question. She tried to, turn it around. But Kamala, Donald Trump has probably, how many people has he paid off to, get their abortion? He doesn't want to have that woman's child. Here, just get it taken care of. Here's some money. Go get it taken care of. So homicide was charged. The defendants allegedly visited an abortion clinic. Okay, so then we go to Amber Nicole Thurman. So interesting things that's happening because of Dobbs. Specifically, they're going to take down trans rights. I don't know. I don't want our children to be a science experiment. I don't want to experiment on the drugs and surgeries with children. So turning the children trans, that is too liberal. When people are talking about the woke liberal, left, that's what they're talking about. They're not talking about the communist left. They're not talking about, the left that wants to house the homeless or have a war on poverty or to stop the wars or to stop police brutality. They're just talking about trans rights. And a trans person has all the human rights as anybody else, all the American rights, all the natural rights. They should be treated just like anybody else. Now, as much as, I don't particularly care about other people's children, if it was my own children, I wouldn't want them to get surgery. I do not want them lopping off or mangling. I do not want genital mutilation happens in Africa. So I don't want any genital mutilation. This is kind of an obvious case, so don't negate trans rights. But to say that children need to have surgery or hormone or puberty blockers, that shit's too fucking much. So the governor of Kentucky is right about that. Now, the other freedoms that they're coming after, the right to reside with one's relatives, you're allowed to stay with your relatives. Why would that not be a freedom? These are fiat SCOTUS created freedoms. So you have the constitutional freedoms, of which we don't listen to. You have a whole bunch of freedoms inside the Constitution, that people don't listen to. But these are freedoms that the Supreme Court case law has said that we have a right to. The right to use contraception, the right to marry. Do we have the right to marriage? Technically, it's not in the Constitution. Also, immunity is not in the Constitution. So you don't have the right to marry. You don't have a right to have children. You don't have a right to reside with one's relatives. You don't have a right to use contraception. You also don't have a right to immunity because it's not in the Constitution as well. The right to not be sterilized without your consent. The right for two consenting adults to have sex in the privacy of their own home. The right to self-defense, the exclusionary rule. That's the Mapp v. Ohio. Unanimous jury notes 2020 Ramos v. Louisiana. These are not in the Constitution, but the Supreme Court has says, yes, these are substantial due process rights that we have via the 14th Amendment, right? You can't just point to the rights in the Constitution. You got to go through the 14th Amendment, and then through the 14th Amendment, it's either procedural due process rights or it's substantive due process rights. And then you have to specifically name the damn amendment. So you have to come back, right? You got to go, well, you broke my 4th Amendment. Well, you didn't say it right. So, okay, you broke my 14th Amendment due process clause to my 4th Amendment right. Oh, okay. Well, that I can hear. That I can listen to. Well, that's a lot of steps just to get to the same damn place, wouldn't you say? The right to refuse surgery or forced administration of drugs. So you have a right to refuse surgery and forced administration of drugs according to 1985 Winston v. Lee. So if anybody was forcing surgery or forcing you to take drugs, you have a right to say no to that. You have a right to reject life-saving medical treatment, 1990 Cruzen v. Director. The right to have children is 1942 Skinner v. Oklahoma. The right to privacy. The great thing about the Supreme Court doesn't like to just create a right out of whole cloth. If it's not in the Constitution, then you really have to have a strong claim. So the right to get married, I think, is an obvious one. The right to stay with one's relatives, the right to have children, I think these are very good rights. The right to self-defense, that's D.C. v. Heller, 2008. It's also the 9th Amendment. The right to the privacies of life, that's the Boyd decision. The Miranda warning is Miranda v. Arizona, 1966. The right to privacy, 1961, Mapp v. Ohio. So are they coming after our right to privacy, our right to bear, to have children, the right to get married, the right to have contraceptions, the right to reject surgery or forced administration of drugs? What other freedoms are they coming after? I think that's a good question. Because if we're ignoring the constitutional freedoms, but we're upholding all these fiat SCOTUS freedoms, what the fuck is the fucking point? Like, Jesus fucking Christ. Freedom is good. And if anything, because the Supreme Court has figured this shit out in opposition to the Constitution, it almost makes me feel like if the Supreme Court said, okay, this here is a freedom, then we should pay attention to it. And it should be basically as good as constitutional law.